As a regular user of Twitter, the revelation of Elon Musk seeking to buy the company was welcome news. Many have asserted that Twitter's employees overwhelmingly hold a one-sided political bias, which stifles public discourse. And given that Twitter has, in many ways, become the de facto public square, it is not an overstatement to assert that Twitter's bias has materially and negatively impacted our society and democracy, even if Twitter is not technically governed by the First Amendment of our Constitution. But after masterfully railroading Twitter into signing an agreement to sell the company, Musk is having second thoughts. On May 17th, he indicated in no uncertain terms that the deal cannot move forward until Twitter's CEO, Parag Agrawal, publicly shows proof that bots and spam accounts make up less than 5% of its users. Twitter responded by filing a proxy statement later that day to approve the sale, apparently fully intending to follow through with the closing. So what does this all mean? Well, Elon's purchase of Twitter is subject to a number of conditions, including that all of the representations and warranties made by Twitter in the purchase agreement are true and correct as of closing. A representation and warranty is essentially a disclosure made by the selling company regarding its condition, assets, and business. One such representation made by Twitter is that none of its SEC filings since January 1st of this year contained any untrue statement of a material fact or omitted to state any material fact necessary to make the statements therein not misleading. SEC filings are public disclosures which are required by federal law to be made by companies whose shares are publicly traded so that their shareholders and potential shareholders can make informed decisions regarding whether to purchase or sell their stock. And in Twitter's annual report filed in February, Twitter disclosed that based on their internal review of a sample of accounts, they estimated that false and spam accounts were fewer than 5% of its total users. This figure is critically important because a substantial majority of Twitter's revenue comes from advertising, which is highly dependent on the number of its real users. Also, Elon's plans to unlock Twitter's potential, whether it be by adding subscription services or otherwise, is also likely heavily dependent on real users. However, some are claiming that even if Twitter's 5% figure is wrong, it would not give Musk an excuse to back out of the deal. They cite the fact that Twitter added disclaimers to its 5% figure, and that the SEC's anti-fraud rules, which provide that a company's public filings must be true and accurate, require something called scienter. Scienter essentially means that in order for a company to be guilty of fraud, not only does there need to be a material misstatement, but that material misstatement must have been willful. In other words, if Twitter's 5% figure is wrong, but it was due to error or even innocent ignorance, their argument is that Musk would not be able to renege on the deal. However, these so-called experts are conflating two very different things. Yes, the SEC's anti-fraud rules do require scienter, but even though the language of Twitter's misstatement rep is based on the SEC's anti-fraud rules, it does not expressly contain a scienter requirement, and generally speaking, in order for a representation in a contract to be breached, no showing of willful intent or fraud is required unless specified. A seller's reps and warranties in a purchase agreement are critically important to any business deal because they tell the buyer what he is in fact purchasing. There's only so much diligence a buyer can do before agreeing to purchase a company, particularly a massive company like Twitter. So the reps and warranties are an efficient way to ensure that the buyer and seller are on the same page in terms of what is being purchased and sold. In fact, these reps and warranties are so important that typically a large portion of the purchase price is held back in escrow to ensure that these representations were in fact accurate. Additionally, it would not make sense to view the misstatement rep as having the same meaning as the SEC's anti-fraud rules from a standpoint of basic contract interpretation. This is because in the same paragraph, Twitter already provided a separate representation that their SEC filings complied in all material respects with SEC rules and regulations, which include its anti-fraud rules. If the intent was for the anti-fraud rules to apply to the misstatement rep, then there would be no point to provide for it separately, since the SEC's standard of anti-fraud is already encompassed by the compliance rep. In other words, by a plain reading of the contract, the parties agreed to include an independent misstatement rep without scienter, in addition to the general requirement that Twitter's filings comply with the SEC rules. What this all means is that if Elon can objectively show that the percentage of Twitter's spam and bot users is materially higher than 5%, then his case to terminate this deal without having to pay the $1 billion termination fee is strong. Now personally, I hope the deal ultimately goes through, but given the current market and share price, it would probably make sense for Elon to have a third-party audit Twitter's spam accounts, then recast the financials based on that audit, and recut the deal at a lower price. And this single clause in the contract likely gives him the path to do so.